Hello, ladies and gentlemen. My name is Tim Gagan, and I'm a lawyer in Quebec. What you're going to be watching today is for legal information purpose only. It does not constitute a legal advice. If you have a real case, if you need a real legal advice, please contact your lawyer. If you need more information, here are several useful links. If you need a lawyer and you don't have a lawyer, please contact the Law Society of Quebec, Barreau de Quebec, and they will help you to find one. What if the defect was apparent, it was visible, and you hired an inspector? An inspector should have seen the defect, but missed it, or omitted it in his report or her report. Then, technically speaking, the seller is not liable. So you cannot go after the seller. It was visible, it was not latent. So your option is to go after your inspector, if he or she has professional responsibility insurance. Well, technically you can go after in any case, because it's a contractual work, so the inspector should have noticed an indication of a problem if it was apparent. The inspector is not an expert. The inspector should not go deep, should not open the floors, for example. The inspector's work is to be your eyes, basically. Well, sometimes maybe to measure the level of water in the ground or something like that with some small tool. But all in all, inspector is there to be sure that whatever should have been observed for, like, in an attempt to find an apparent defect, was properly observed. So if an inspector was diligent and he didn't see any defect, then what he didn't see is by definition latent defect. But if it was visible and the inspector missed it, then the inspector is responsible for breaching the contract, because you contracted the inspector to look for you and to find whatever was there to find. So sometimes you're again in this situation, like, who is responsible, the seller or the inspector? You don't know. And for that, you might need to hire an expert to tell you, was it really visible? Was it really the source of a problem, what was missed? And if that was the case, then you go after the inspector. If the inspector duly, diligently found whatever should have been found, and whatever really caused the problem was not visible, was not apparent, then it's the seller's responsibility. You cannot go after both for the same thing. It's either one or another. Well, in most of the cases. So, when you hire an inspector, it's a good idea to understand if the inspector is able to pay in case. And for that matter, you want to know if the inspector has professional responsibility insurance. In Quebec, at least as of now, being an inspector is not a profession that is like really limited. So the inspector is not obliged to be a member of some organization and to follow some particular rules. So basically, it's on you. You can do the inspection on your own, first of all. You can ask your neighbor to do it for you. But if you hire somebody for money, if it's a contract, then there might be a contractual responsibility for the breach of the contract, or for like undue performance of the contract, bad performance of the contract. And then if you go after the person, and if the amount is significant, which might be, it's better to know that your inspector had this insurance. And as I mentioned, not every inspector has it, because not every inspector is a member of some kind of organization. There are several in Quebec. Some of them are given here, at my right, your left, and there are others. And they have their own standards, they have their own codes of ethics, which again are not legally obliging in a sense that if they breach those standards and those codes of ethics, they're necessarily and immediately at fault, but it would help you to prove their fault if they were members of those organizations and if those organizations had, again, rules, standards, and code of ethics. Uh, but of course, you might expect that the rules would be vague and the code of ethics would be written less in your favor than you would expect. So, major, again, uh, advantage is that professional insurance, professional responsibility insurance. Would be play in your favor again if ever you're in court, if you could prove that you were diligent when you hired an expert, that you collected information if you're really a member of some organization, if that organization particularly has strict rules that you would want your inspector to follow, and so on and so on. Because again, if you hired whoever and you just believed without any kind of verification, and then later there appeared to be a problem, this kind of hiring whoever might be again used against you to show that you were not diligent enough. I'm not saying that it's again black and white. Those are nuances which could influence the appreciation of the facts by the judge. So it's better that you are duly diligent from the beginning, from the moment when you are thinking to hire an inspector. So hire a good one. As I mentioned, the professional code, the Code de Profession, does not apply. So whoever can be an inspector, at least as of now. But Article 2098 and following of the Civil Code of Quebec also sets rules about professional responsibility of a contractor. So if somebody is contracted to do some work by the code, that somebody is responsible to do that work according to the standards and rules of the industry. So again, if that person was not a member of an organization, it would be on you to show what are the standards and rules of the industry. But technically speaking, you could take those rules and standards from several professional organizations of inspectors and show that, well, normally this is what is expected from an inspector. Again, the inspector could get a defense saying that he was duly diligent. For example, he did everything she should have done according to his professional rules and standards. And if he still missed something or she still missed something, that was not his or her fault or negligence. Because according to the court decisions, court of appeal decisions, the inspector is not obliged to deliver you 100% result. The inspector is obliged to use proper means to do his best, basically, to get you the result. In the same sense as you would expect from yourself if you were doing this visual inspection around. Because, well, there is always a chance that you might have missed something, but you should do your best, at least. And that's what you expect from your inspector. So if you think that the inspector simply didn't go where he or she should have, didn't look where he or she should have, didn't note what he or she should have noted, didn't put into the report what he or she should have put into the report, so he or she was negligent, and because of that you're suffering, you're seeing the problem, you're losing money to repair. In that case, in that situation, you can go after the inspector. But do remember that if you're not sure if it's the seller or inspector, do not hurry to decide who is at fault, because You might say that it's the inspector's fault, that it was visible. By that, you sort of admitted that the seller is not at fault. Then it would appear that it was not so visible, that the inspector uh, was not negligent, and voila, you don't have anybody to go after. So before making decisions, it might be a good idea, especially if it comes to significant amount of money, it might be a good idea to hire an expert and let the expert to decide who is at fault. Was it apparent? Was it not apparent? Should have the inspector seen it, notice it or not? And only then you decide what you reclaim from whom. Here is their article in the Civil Code, which basically gives you a reason to go after the inspector if you hire the inspector again as a contractor, like properly. It's significantly less possible to go after your friend who agreed to go there with you and to help you out of pure like good heart, pure heart kindness. But if somebody sold you his services or her services, then you can go after that person if you think that that person was not diligent enough, if you think that that person was negligent. One of the, well, usual at least, responsibilities of the inspector is to tell you if you need an expert or not. So basically, inspector not only should have noticed if something is wrong or potentially wrong, but the inspector should have drawn your attention to the fact that, okay, this is unknown, this is might be a problem, might be not, and you have to call somebody who would tell you in advance if this is a problem, if it's like money loss kind of a problem, or if it's just nothing, or something which would not be really a bad thing later on. So if you don't see that in the inspector's report, if you see that there is some potential problem and there is no recommendation, don't be shy, ask your inspector, preferably in writing, to receive the response in writing, if you should have done that or you should have not done that. But be prepared that the inspector, just out of fear for his own professional responsibility, would tell you, yes, you need an expert, and you will then have to pay or look for another piece of property.